Hey everybody, John Skiba here from the Arizona Consumer Law Group. And in today's video, I want to talk about how much time you have to file your written response to the debt collection lawsuit that you were just served with. Now, one thing that's important is this is going to be for Arizona residents only. I practice law in the state of Arizona, and Arizona's rules, the rules of civil procedure that govern when the response is due, are a little bit different than a lot of other states. So if you're listening to this from a different state, this may not be applicable to your state specifically. But if you are in Arizona and you were recently sued with a debt collection lawsuit, how this works is you have 20 days from the day that you were served with a complaint and summons. Now, question is, how do you know if you were served? Now, it's obvious if a process server came by your house, knocked on the door, and dropped off the complaint and the summons. You then have 20 calendar days to respond to that lawsuit by filing a written document called an answer. This is the document that tells the court whether you admit or deny the allegations of the plaintiff or the debt collector in your specific case. And so you have 20 calendar days from the day that they dropped it off. Now, something that you'll see in Arizona that's a little bit different is sometimes the courts will authorize what's called alternative service. If the process server comes by your house, they can't catch you home, or you're avoiding service, something I tell people not to do. But if you're avoiding service or just not answering the door, then they can go and get an order allowing alternative service, which in Arizona, typically they require the plaintiff to mail you a copy of the complaint and summons and to post a copy of it on your door. Once they accomplish those two things, that's when that 20-day window starts ticking. So, and it's always kind of hard to judge because, you may get it in the mail one day and they may post it on the door the next. I always say once you see that complaint and summons posted on your door, or if you don't see that and you see it come in the mail, that's when I would start counting the 20 days. Now, that may make some people a little bit uncomfortable, but one thing that's nice in Arizona is that we do have a little bit of a grace period built into the rules. This is what's different about the Arizona rules as compared to some other states. A lot of other states and the federal jurisdictions do not have this kind of grace period built in. Let me tell you how this works. So if 20 days goes by from the time you were served and you don't file a written answer with the court, at that point, the plaintiff, the debt collector, they will file something with the court called an application for entry of default, and they're going to mail a copy of it to you. And from the day that they mail that to you, you then have 10 business days to file a written answer with the court. This is kind of the court's way of saying, are you sure you don't want to file a response to this? Because if you don't, we're going to enter a default. Now, the thing that gets a little bit tricky with this is you have 10 business days to respond. So the weekends and holidays don't count. That's different than the initial time period where you had 20 days to respond, because that 20 days includes weekends, holidays, everything else. So when you very first get served, you have a 20-day window to respond. That includes weekends. It's just straight 20 calendar days. However, if you get an application for default, you then have 10 business days to file your answer with the court. You do not count weekends and holidays. The other little tricky thing on this is you have 10 business days from the day they mailed it to you, not from the day that that you actually received it. So you'll have to look on the last page. There'll be a little box down there that says where they signed it, saying the day that they mailed it to you. That's where you start counting that 10-day period. So that can get a little bit tricky. That's why you may want to listen to this a couple of times if you're in this situation. But as long as you file your written answer with the court within that 10-day period, you're okay. You're not going to end up with a default judgment. However, if you ignore it and you still don't file a response, at that point, the clerk will enter a default, and eventually the judge will sign off on a default judgment. So that's kind of how the rules work in the state of Arizona as it relates to debt collection cases, whether it's a justice court case where the amount in dispute is under $10,000, or whether it's a superior court case where the amount is over $10,000. If you want to learn more about how to draft an answer, you can head on over to my website at consumerwarrior.com. I have a template there that can show you how to do it. I even have an instructional video that takes you step by step on how to draft an answer. And we can obviously meet with you in my office and really walk you through all the defenses that you have to these debt collection suits and ways to resolve them. Appreciate you watching today.